So for today's seminars, we're very privileged to have three excellent speakers who are going to speak for roughly 10 minutes each, leaving ample time for Q&A at the end. I'm going to start with a short introduction to provide some context before handing over to Penelope Gibbs, who's the Director of Transform Justice, Jane Smith, Chair of the Magistrates Association Central and North London branch, and Andrew Nicholson, who's a retired Senior Legal Advisor. I'm then going to open up to the Q&A. You can submit your questions throughout the event on the Teams Q&A function, which should appear as a tab at the top. We hope you enjoy it. But before I hand over to our speakers, I'm just going to introduce them and then say a little about the Single Justice Procedure, or SJP, as I'm likely to refer to it. So firstly, Penelope Gibbs runs the Transform Justice charity. She's previously sat as a magistrate for a few years, but before SJP was introduced, Penelope has studied SJP on and off since it was introduced and has liaised with MPs, written articles and produced a podcast on the subject. But she's never actually written a report about it, although currently she's actively gathering evidence for a briefing which should be out early next year. Jane has been a magistrate for 15 years and sits on the Central London bench. She's a Deputy Chair of the Magistrates Association Adults Courts Committee. Jane has experience of single justice cases along with all the other sorts of work that magistrates do, and she'll touch on her experiences as well as giving the MA's view on the SJP. Andrew Nicholson's a retired Senior Legal Advisor who spent 36 years working in the Magistrates Courts until his retirement in May of this year. Andrew was the SJP lead for London and was heavily involved with the introduction of the procedure, both on a day-to-day and management level, working closely with colleagues throughout England and Wales. He's going to provide a legal advisor's insight into how SJP works and how these cases were processed before it was introduced. So that's our speakers. Now, just a few facts about the SJP. It accounts for over half the cases that magistrates consider, well over 500,000 cases. It can only be used for adult summary, non-imprisonable offences. Most of these are motoring cases. The next largest group are cases brought by DVLA, with a much smaller proportion of cases accounted for by TV licensing and Transport for London, as well as others. It was introduced in 2015 and it replaced processes set out in the 1957 Magistrates Courts Act, changing some of them but continuing practices such as trial in absence and postal service of prosecutions, which have been in place for much longer, some up to 300 years. So that's what we're talking about, a system in place for little less than 10 years, but including practices in place for centuries. And with no further ado, our first speaker. Over to you, Penny.
Thanks very much indeed. And I'd just like to say that I absolutely understand why the single justice procedure was introduced. It was introduced to save time and money, both for the system, but also for defendants. And it really does do that thing. So if you're accused of one of these lower level offences, what happens is that you have some encounter with an enforcement officer, maybe a ticket inspector on the tube or something like that, and they decide that you've committed an offence. You will then receive a letter in the post. You might receive two letters, one saying you are going to be prosecuted. The next is actually the prosecution notice. And that can be done and dusted in weeks because you can go online, fill in a form, and you're likely to get a fine if you pleaded guilty, and then you pay it and it's done and dusted. So for cases where people understand the whole process and go through it, it works well. I suppose what we're interested in at Transform Justice is where it doesn't work so well. And one of the issues, I want to kind of look at two key issues, one about how they're prosecuted, and secondly, about participation. There are other issues, but time is precious. So the first thing I want to talk about is, do the prosecutors know enough about those that they're accusing of the crimes? So as I say, there's always going to be likely to have been an encounter with an enforcement officer, though in the case of DVLA, maybe not even that. And my understanding is some prosecutors send pre-prosecution letters, but I don't think all do. This means that the prosecutor knows very, very little about the person they're accusing. They, the enforcement officers are not trained in investigating people about whether they're vulnerable or asking about disability or anything like that. So what we get is people being sort of prosecuted in the dark, really. And it's a name and an address for the most part for the prosecutors. And what happens that we can see from the work of a very good journalist called Tristan Kirk is that some very vulnerable people have been prosecuted and in fact convicted. So Tristan Kirk, who is courts reporter for the Evening Standard and has done some amazing work on this, has got hold of the actual forms that people fill in. The prosecution forms, if you're pleading guilty, you fill in the form. And there's a space for mitigation, that is for kind of what the person wants to be taken into account when the judge is deciding on the sanction. And in that form, which Tristan kind of uploads onto social media quite regularly, you see examples of, as I say, very vulnerable people who've been prosecuted, people with dementia, or there's a man who was actually in the process of dying, who was prosecuted for not having the right road tax. And in another case, somebody had long COVID. And then also what comes out sometimes in this mitigating paragraph that Tristan Kirk is finding is that, to be honest, some people look as if they shouldn't have pleaded guilty in the first place. So people who actually didn't own the car where they're being prosecuted for not having the tax on it. So I think our first concern is, do the prosecutors know enough? So the Crown Prosecution Service, which is, by the way, not involved in this whatsoever, all the prosecutors are kind of state bodies, but not the Crown Prosecution Service. It's the police, local authorities, rail companies, the BBC, etc. The CPS makes decisions on prosecution on the basis of the evidence they have, but also whether in the public interest prosecuting that person is the right thing to do. And when they make that judgment, the CPS always looks at the context to the crime and also who is accused and their vulnerabilities. This does not in any way mean that just because somebody has a mental health problem, they're definitely not going to be prosecuted. But the CPS takes it into account. They take all circumstances into account in judging whether the prosecution's in the public interest. And so I think we have a problem where the prosecution doesn't have that information that say the CPS uses. And what we see ending up is some of those accused clearly maybe shouldn't have been prosecuted, or at least that information should have been available to the prosecutor before they press the button on prosecute. So that's one issue. Do the prosecutors know enough? The second issue, which is of concern, which is about participation in the process overall. So Kevin said the majority of magistrates' courts offences are single justice procedure. I actually think it might be the majority of all criminal offences now being single justice procedure. So we're talking about an awful lot of offences, and the evidence is that most people do not respond to the prosecution notice. So basically 2/3 of people do not plead guilty or not guilty. Now, we really don't know why. Nobody knows why. Everybody's got ideas, but we don't know why. One thing it could well be is that some of the people don't receive the notice at all. So it's sent snail mail, not registered mail, not signed for, and no second letter is sent before the prosecution is actioned. So lots of people live, to be honest, some chaotic lives where they don't get their post. They may be in a block of flats, they may be sofa surfing, they may have changed their address and not understand that they were supposed to have informed the authorities about that. So we don't know how many people actually received that letter in the first place. But secondly, if you go back to the vulnerability point, I mean, Tristan's work shows that a lot of people who are accused are very vulnerable. How many more who don't respond because of their vulnerabilities? So they could have mental health problems. They could have be neurodiverse and have issues with kind of just dealing with these kind of forms. They may not understand the form, whether for learning difficulties or language reasons. The problem with this lack of participation is we just don't know. There are some people who go back to court having reopened their case because they say they didn't receive the form in the first place. But there may be others who just are paralysed by the process and don't even do that. And the people who don't plead, so if you get the prosecution, or no, if the prosecution notice is sent and you don't plead guilty or not guilty, you are assumed by the court to be guilty. And in general, 99.8% of them are convicted in court in their absence on the basis of the prosecution case. And they will be fined without, as I say, them having said they were guilty or not guilty. Now, it could be that people are putting two fingers up to the justice system, but 2/3 of defendants putting up their fingers up to the justice system seems a bit high and unlikely. And the vulnerability information from Tristan indicates that there might be an issue there. So I think I would say, can we get the 2/3 down? That's 2/3 not participating in their own prosecution in the justice system. And that's an awful lot of people. And I think there's even a credibility issue for the justice system if the participation rate is so very low. So I've got my 10 minutes up, and I would just say I'd love us to, not to get rid of this system, but to have an inquiry, maybe by the Justice Committee or the government, a really open process where we can get all the information out and really find out why the participation rate is so low. Thank you.
I was on mute. Thank you very much, Penny. I'll now hand over to Jane.
Thank you very much. Good afternoon, everybody. I think there's much that the Magistrates Association would agree with Penny on this. Just a general comment to start with. I think she said it's a challenge for the single justice procedure dealing with people with vulnerabilities. I think it's a challenge for the entire court service, actually, and indeed most public services to deal with people with vulnerabilities. But that's a wider question. Kevin's helpfully given the context to this. We're talking about low-level finable only offences, and they've always been characterised by people not responding to the summons letter, even when they were done in court. I don't know whether the figures were different then. Maybe Andrew can tell us. And therefore, if people provide no information whatsoever, then they are available to be proved in their absence because the court has no knowledge of what they want to say. When they used to happen in court, picture an empty courtroom except for two or three magistrates, a legal advisor and a prosecutor. There was no public there because there wasn't much to see. And after, maybe one or two people turned up to plead not guilty or to mitigate, but after they'd gone, and then it was all being dealt with on the papers by the prosecutor. Penny's mentioned the prosecutor a lot, and I'll come back to him or her as well. The prosecutor would outline the case, and if there was no response from the defendant in person or by post, then magistrates would proceed to prove an absence, provided the procedure had been done properly, and I'll come back to that. And then you apply a fine based on no information on income, on the costs, the compensation if it's a rail fare or a tube fare. So yes, it can be formulaic. It always was, and it still is. Nevertheless, magistrates do have to be on the ball. They have to check that the summons was served correctly, that the charge was made in time, and sometimes they're not. And for somebody who's 18, that they weren't 17 at the time of the offence, because as Kevin said, the single justice procedure only applies to adult offenders. And you need to look for previous convictions and the circumstances of the offence, both of which can affect the sentence. So that same process is now done online with one magistrate and a legal advisor. And there's also a 3-to-1 process where 3 magistrates do it, backed up by one legal advisor. And as Penny said, in many ways, that's an improvement. It spares defendants the need to come to court. And for many, responding online is easier, and it allows for more efficient use of court time and magistrate resource. They can concentrate on the more serious offences where defendants do have to come to court. So the Magistrates Association's position is that the principle of a single justice procedure done online makes sense for the vast majority of cases. And Kevin told us 500,000 a year. That's a lot. And it works well for low-level offences that are finable only. However, the MA, like Penny, considers that it could be improved. We did a survey of our members earlier this year, and as a result made a series of 12 recommendations, which are in a published document. Penny highlighted the role of the prosecutor, and I think we'd like to do the same. We would like prosecutors to see she's right that prosecutors in these cases probably don't know much about the defendants because they don't say much. But actually, under the single justice procedure, we understand that they don't see any of the paperwork before it comes to court, and we think they should. In the old days, when it was in court, they did, and that's probably the key difference between them being in court and now. We'd like to review the training. There's an online module for magistrates, and I went and redid it the other day in preparation for this session. And actually, it's pretty comprehensive, but also to make sure that the magistrates doing it are experienced enough. They need to have been through their mentoring process and to have passed an appraisal as being competent, had a fair number of sittings, and be confident about making decisions on their own with a legal advisor. The training does actually now, I think, newly emphasise the magistrate's ability to give a discharge in certain cases or to refer it back to the prosecutor so that they consider whether it is in the public interests to continue the prosecutions. And I think there's also been a recent communication from the Justices Clerk Society reminding legal advisors about how to refer to the prosecutors. Some magistrates in our survey did report feeling under pressure to get through the work. And I believe that legal advisors do have some locally imposed targets to get through a certain number in a week or a period. Now, my experience is that legal advisors are not pressurised need to do it fast, and a few colleagues I've spoken to have said the same. But I know that in the survey, several magistrates did report they felt under pressure. Having said that, I think it's up to magistrates to resist that pressure and do it properly and do it at the speed they feel is necessary. And also, having said that, it is possible to do the cases with no information quite fast. So there are some recommendations around transparency. Journalists can get lists and outcomes, and the MA suggests that they should also be able to observe sessions, just like they could in court. Magistrates have got nothing to hide on this. And being more transparent in general. publishing more data on the numbers. I mean, it's clearly a very high proportion of court work, so the public should know more about it. And in particular, more publicity to tell people to engage. This is Penny's point as well. I noticed that the government's website refers people to the Advice Now website, and the first bit of information they give about people who've had a single justice notice is to respond and to do it within the deadline. Because if they don't respond, then there's not much that anybody can do. And in most cases, with many prosecutions, maybe not all, there has been a stage before it reaches the prosecution when the person could have engaged with the prosecutor, paid a penalty fare or a fixed penalty notice, sent in an explanation, sent in evidence of being in hospital or whatever, that could have avoided the summons and the SPJ case. So engage. And I think the MO thinks that research into what help could be provided for people who find it harder to engage would be helpful. It's those vulnerable people again. And improving communications make it simpler to understand the notices. In my experience, magistrates do take this work seriously, and they can and do refer cases back to prosecutors. And I think maybe since there have been the press cases and the Magistrates Association has publicised this issue and made its recommendations, and other people, I think magistrates are more aware of their ability to refer back to the prosecutor, and or to refer it into court. If the pleas are equivocal, for example, then that's what you would do. That's what you would do in court, would have done in court, and it's what you do now. So yeah, I think that at many levels we'd agree with Penny's analysis and think that the system, we should work to make it better. Thank you.
Thank you, Jane. That's really helpful. Over to you, Andrew.
Thank you. I was heavily involved in the development of SJP, as one of my courts at Lavender Hill was the pilot court for single justice. And then subsequently, I worked very closely with the developers of the Common Platforms solution for SJP, i.e. ATCM. And Lavender Hill was also an early adopter for 3-to-1 working, so up to 3 magistrates working with a single legal advisor. So I have had a lot of experience of single justice work. And I believe it's a proportionate way of dealing with the hundreds of thousands of low-level non-imprisonable offences that are dealt with every year. But I do totally accept that there have been mistakes in how some of the cases have been dealt with. But to my mind, I don't think that wholesale changes are required. Two of the biggest points that are perhaps made about SJP is that, one, that this is sort of secret justice, and that secondly, that defendants are being convicted where it's not in the public interest. I actually think that suggestions that somehow this is secret justice are wide of the mark. As Jane's already said, we provide the media with the Excel media register, which has all the cases that have been dealt with in single justice sessions, and the register can be filtered by age, court, outcome, etc. And again, as Jane's already said, the media have access to the papers in these cases other than the means form. And the level of reporting that we've seen on individual cases would perhaps suggest that this is far from being secret justice. That scrutiny has been quite helpful because it has actually enabled us to identify cases where errors have been made. Before SJP, there was very little scrutiny, very little reporting of these cases other than the odd high-profile case. And I know Jane just mentioned that perhaps the media ought to be allowed to sit in some of these sessions, but in reality, there wouldn't be very much for them to see because there's not a lot being said in these sessions because it's around magistrates reading papers for themselves. Dealing with the second point about cases in the public interest, I was very clear when we introduced SJP that no one should be disadvantaged by having their case dealt with under the procedure. And it was a point that I made to my legal teams time and time again. Where it's possibly not in the public interest to prosecute, as has already been mentioned, the case can either be adjourned into open court or back to SJP for the prosecutor to review. And magistrates do it, and as a legal advisor, I regularly did send cases back for them to be reviewed. And I know that some prosecutors now have dedicated inboxes if a magistrate or legal advisor wants to refer the case, so that quick decisions can be made. I totally accept that some cases that should have been referred back weren't, but it is an exercise of discretion and judgment. And in many of the reported cases, the magistrate has clearly had regard to the circumstances, as it has been reflected in the penalty, with an absolute discharge being imposed. I think it's also worth mentioning, as Jane's already said, that in a lot of these cases, there has been the availability of contact prior to the proceedings being instituted, and that cases could have been settled without them ever coming to court. I do think it's also sometimes overlooked that before SJP was introduced, written pleas of guilty weren't always being dealt with in the presence of the prosecutor. And that could happen in two circumstances. Either another court would offer to assist with this work because their list had gone short. When that happened, the prosecutor would just be told the outcome of the case. They wouldn't see the papers. And also because Section 12 of the Magistrates Courts Act allowed a 4-week window to deal with written pleas of guilty. So sometimes they weren't actually being dealt with on the day when the prosecutor was present at all. And in my experience, and I used to do quite a lot of these bulk courts back in the day, it was very rare for a case with a guilty plea to be withdrawn on public interest grounds. But of course, in those days, there was very little media interest in this sort of work, so cases weren't being reported. So I'm not sure there were more cases being withdrawn on public interest grounds then than there are now. And I think in many of the cases that have been reported, what's actually written in mitigation is just that, i.e. substantial mitigation, which is reflected in the penalty imposed. One other thing that I'll also mention at this stage, it was after my time, but perhaps I ought to mention the railway cases that were recently dealt with by the Chief Magistrate. Obviously, that was an error that had significant ramifications because clearly now many thousands of cases may have to be reopened. But I think it is worth remembering that there was prima facie evidence of an offence in these cases sufficient to justify prosecution. Had the prosecutor applied for summonses, they would have been properly brought. The error was the process of getting the cases before the court, but I totally accept that's an error that shouldn't have happened. And I know it is sometimes said that SJP cases are dealt with very quickly, hinting that perhaps they're not considered properly. And again, that certainly isn't my experience. But before SJP was dealt with, we would often list more than 100 cases in a morning in a low-level bulk court. As Jane's already said, a handful of defendants would attend. There would be some written pleas, but the vast majority of cases were dealt with in absence. But I think I should make the point that if a case is dealt with in absence, there's not an assumption that the prosecution is correct. The case still has to be proved to the criminal standard. And under SJP and before SJP, some cases were dismissed where that evidence simply isn't there. But before SJP, we comfortably got through 100+ cases in a morning, despite the bench needing to agree the outcome in every case. And I think it is the same for both SJP and non-SJP cases. Very straightforward matters dealt with in absence can be dealt with pretty quickly. Totally agree with Jane and Penelope. I think everyone would like to see more defendants engage in this process, but that's not an SJP issue. As we've already said, it was the same prior to SJP. And I know there have been comments about the SJP notice, but to my mind, I actually think it's probably clearer and easier to read than many of the old summonses that were sent out and the requisitions that are still sent out. It was developed by experts. I remember it being developed, and I remember it being user tested as well, and receiving some quite positive feedback from those who did test it. But I do accept that there is probably still too much that is sent out in those packs. But it was the same with requisitions and summonses, and I doubt many people actually ploughed through the whole pack from beginning to end. And I do wonder whether that's what puts some people off from actually engaging in the process, is that they're sent sort of 12, 13 pages to read, and they simply give up. I do think online pleas are a big plus, because I think it has made it much easier for defendants to engage if they've got access to the IT. And I do think it's worth remembering that, yes, although a lot of cases are reviewed, are sort of dealt with in absence, fines can be reviewed if the defendant subsequently gets in touch with the court and provides their financial information, and there's a statutory basis for doing that. All cases can be reopened. If the defendant's not aware of the case, they have an absolute right to make a statutory declaration within time. And a defendant clearly has a right of appeal to the Crown Court, should they wish to do so. Personally, I don't think you'll improve engagement by changing how the notices are served. They are served by first-class post. I do remember the day when summonses used to be sent out by recorded delivery. But what actually happened was that, in my experience, around half the list or more ended up having to be adjourned for a further attempt at service, because with recorded delivery, defendants either just did not collect them or they refused to accept service. And I suspect that's probably part of the reason why we ended up going towards first-class post. And I personally don't see the point of sending out the notice twice. I think if it's been sent out once and a defendant doesn't respond, I don't think they're likely to if we do it again. I think one of the big positives of SJP, to my mind, is the fact that the magistrate reads the documents for themselves rather than it being read to them or summarised. I think it's much easier to digest something if you're reading it for yourself rather than having to listen to somebody else reading it to you. And I know Jane mentioned about pressure being put on magistrates and possibly legal advisors. I think when SJP was introduced, we were very clear that there was no expectation that magistrates would deal with a particular number of cases in a session. In fact, in London, we stopped talking about a list because we wanted to get away from them thinking that they had a list to complete. One of the advantages of SJP, of course, is it is a lot easier to pick it up in downtime. So if a court goes short or if there's a break in the proceedings. I do accept that if a magistrate is dealing with very few cases, a tiny handful in a couple of hours or whatever, it may suggest that there's a training need. But certainly in London, we only checked that if it was drawn to our attention. We monitored case numbers because we didn't want backlogs to build, and I regularly nagged colleagues about it, but we weren't looking at the performance of individual magistrates. And yes, we did have numbers that each region was expected to complete, but the way around it was that we would run additional sessions because it's much easier to run them outside a courtroom if we weren't dealing with the number that was expected of us. I want to mention 3-to-1 working because that's the sort of latest development in single justice, where a single legal advisor supports up to 3 magistrates who record their own outcomes. In my experience, I actually think it's worked quite well, although personally I wouldn't extend it to road traffic work. And I can say that now I'm no longer a civil servant, because I do think driver records, DVLA driver records can be challenging to read, even for experienced legal advisors. But for things like TV licensing, fare evasion and the like, I do think if magistrates have undertaken the training and are properly briefed by the legal advisor, they are more than capable of working with up to 3 magistrates with a single legal advisor. We did a lot of in-depth checking, both during the pilots and subsequently, and that was going into the papers, looking at all of the papers, any responses, etc. And the error rate was very low. I think I agree with Jane, training is the key for single justice work, both for magistrates and the legal advisor. I also completed the Judicial College Pack before I retired, and I think it was good and very thorough. And I know that training is provided for new legal advisors, and that's being developed further. But I do think in many ways it's no different to when these cases were dealt with in open court, and some of this bulk work still is dealt with in open court. I think, the procedure may be a little different, but the basic legal principles are the same for other criminal work. And my last point is that SJP has enabled us to use our courtrooms for more serious work. During the pandemic and its aftermath, the ability to deal with this kind of work remotely sometimes helped magistrates' courts recover pretty quickly. It's also helped us to cope with a reduced court estate because a lot of magistrates' courts have closed. And while some magistrates don't like SJP, I spent many years hearing a lot of complaints from magistrates about how bulk lists being dealt with in open court wasn't a good use of their time. So I think overall SJP has been a step in the right direction. Thank you.
Brilliant. Thank you, Andrew. That was really, really helpful. And thanks to all our speakers. Right. OK, I'm going to run the Q&A session now. There's a few questions come in. Can I just warn Andrew, who's just finished speaking, that I'm going to ask him to speak about some of the about the factual ones that have popped up. And while I give people a chance to sort of hit their keyboard and ask a few more, I'm just going to do something I probably should have done at the beginning, which is declare a slight interest in this subject, because I was the former chief executive of HMCTS, and I was also responsible for criminal operational policy for quite a long time. So I have some skin in this game as well, although I'm now retired and I'm allowed to have my own opinions. And one of the things that always occurred to me when I was discussing the SJP, and it's something I'd just like to ask Penny about really, is Penny, how much do you think your concerns actually relate to the SJP itself, or, for example, prosecution policy, support for the most vulnerable, and participation in the justice system? Because I mean, one particular point that always struck me is when I was responsible for civil justice, one of the big issues around debt was the fact that people were all constantly getting CCJs against them because they hadn't changed their address, they hadn't notified people who've changed his address and things like that, and their lack of participation in the civil justice system was at times and sometimes even more damaging than lack of participation in the criminal justice system. And it's at times like that I found myself thinking, well, maybe we should have a national identity card after all, because some of these issues would go away if we actually knew where people were and knew a bit more about them. But so sorry, a bit of a monologue, Penny, but I'm always struck by concerns about the SJP as to whether they are about the SJP or whether they're about wider issues in the justice system. And I wonder what your thinking was on that.
To me, it's wrapped up in the process, in the prosecutors we're talking about, these non-CPS prosecutors in general use the single justice procedure rather than open court processes. So it's a bit wrapped up in that. Right. And the issue about lack of participation in the justice process, totally agree. It is a challenge. I would say the figures I've seen say that non-response rate has actually increased with the single justice procedure, can I say? So yes, there was a lack of people turning up at court for these kind of offences previously, but when I last looked at the data, it's actually got worse with this process. And the other thing I want to say is people thought that the online kind of form was going to make the difference, and it hasn't. So it is clearly something between if somebody receives it and their kind of reaction to it. And yes, people, it'd be lovely if everybody did just get the form and fill it in. But to me, it is about the credibility of the system. If 2/3 of the people do not respond, there will be a reason which has to do with their circumstances, their issues, etc. And if the justice system is not fit for purpose for 2/3 of those accused of these criminal offences, I think we need to adjust the system a bit.
Yeah, all fair points, I think. I mean, I think I mean, it's really interesting, this issue about non-participation. Although there are definitely people who don't participate because it's in their interest to not participate as well, particularly high earners in this area. But I think we'll continue that debate as we move on. Andrew, have you had a chance to have a look at some of the questions? I mean, I think Phil asked one about fines. You might want to talk about that, and then there was some questions about who are the prosecutors, which we might have covered, but it might be worth reiterating, and about the system distinguishing between people. I mean, Penny and Jane, feel free to come in after Andrew's talked about those as well.
Yes, in terms of the fines, if a defendant doesn't respond, then there is an assumed relevant weekly income of £440. Magistrates can deviate from that if they think it should be a higher or lower amount, but that's the basis upon which the fine is likely to be determined. I did mention that if a defendant subsequently contacts the court, or if during the enforcement process it becomes apparent that their income is substantially less, or they just provide financial information, then there is a statutory discretion for the magistrates to reduce the fine and the surcharge to what it would have been had we had their financial information. And that happens fairly regularly, or they can still apply to reopen the case, or if they weren't aware of the case, as I said, they can make a statutory declaration. So yes, there are, in a lot of cases, they're dealt with in absence. Quite high fines are imposed, but there is redress.
I would say I think some people also find the level of fines slightly disproportionate. So if somebody had the wrong bus ticket, value normally around £2.50, and they end up leaving the court with fines and costs amounting to kind of £400, that is a lot. And sometimes when I look at the fines from the single justice procedure processes and compare them to the kind of fines in the open magistrates court, I'm quite surprised.
Can I just respond to that, if that's okay, Kevin?
Go on, Andrew, yes.
If somebody's on benefits, for instance, and they don't pay for their bus tickets, then it will be a deemed relevant weekly income of £120. It would be a band A fine, which would take it down to £60. If they've pleaded guilty, they'll get a third off of that, which will take it down to £40. And it could be further reduced for mitigation, of course. Then generally in those cases, the prosecution costs will be substantially reduced, potentially down to £40 or less. And then there will be a surcharge, which the court has to impose, which would be 40%. So that would be £16 unless the surcharge has gone up since I left. And then there'll be compensation. So in fact, the actual amount that is likely to be imposed on someone who engages in the process is significantly less. I think you tend to see the higher fines when people don't engage in the process. And so you've got the assumed weekly income, full costs, and a higher surcharge.
So back to issues about engagement. Jane, you've asked to come in on this interesting issue of sentencing policy and its application.
I'd just like to add a comment that Penny's contrast between the fines she sees from the single justice procedure and those given in court, I think are largely explained by the fact that in court you will have somebody before you who, if they haven't provided information on income, you can ask them there and then, and you can moderate the prosecution costs and obviously adjust the fine according to the income, just as Andrew has explained. Given the large number of cases that just people that just don't engage with single justice, then they end up with the formulaic full costs, full fine and full costs. And actually, even then, you don't have to apply the full costs, although we know that that's actually what the prosecuting authorities say it costs them to prosecute these cases. So you need to have a reason for doing that.
Right. Thank you, Jane. That's really helpful. I mean, the one of the things that always strikes me as odd about the system for setting fines is if you're a very high earner, it's much better not to tell the court anything, because the court will assume a level of income, and you will get a much lower fine than if you'd have actually engaged in the system. It's always struck me as something slightly odd about the system. Andrew, there's a couple of points about posting that's come through. You've probably got the longest memory of us in terms of the posting process. So I'm not suggesting you go back to 1957, I mean, certainly it's been my understanding that we had issues with recorded delivery and lack of acceptance and people not engaging. And that I've never seen changes to posting systems being a solution, but I welcome your thoughts. And on the point about email, I know you've already put in a plug for the online guilty plea, which again I'm a fan of. It does make things as simple as possible for people. But have you got any thoughts on that?
In terms of emailing, service by email, that would be a matter for the Criminal Procedure Rules Committee, of course. But yeah, as I said, I do remember the days, particularly in traffic lists, where everything was served by recorded delivery. The response rate wasn't any better than it is now. Huge numbers of cases were having to be adjourned for personal service of summonses by police officers and things. And I suspect that's why it was abolished in the end, and it went towards first-class post, because it simply isn't really a good use of time trying to personally serve summonses on individuals. And posting is to the last known to the registered last known address, isn't it? So it is the address that they gave to the person either when they were stopped, or it's the address that DVLA hold. So that there shouldn't be any reason in the majority of cases for a lack of service.
Thank you, Andrew. Can I just welcome Tristan, who's I'm assuming is Tristan Kirk, who's really helped shine a light on some of the things that's been happening in the single justice procedure. Tristan's asked a question about presumption of guilt. I don't know whether and rail fare evasion. I don't know whether Andrew or Jane would like to talk about this one.
What is the exact question?
It's quite a long question. It's asked 3 minutes ago, so it might need a bit of a refresh, Jane.
Shall I read it out? It has been said that there isn't a presumption of guilt by magistrates in cases where a defendant hasn't responded. I've recently been looking at rail fare evasion, where the SJP notice contains the basic charge, a statement of the offence, which is essentially a repetition of the charge, but no statement of evidence to support the charge. I believe a statement of evidence from the police officer, TV licensing officer, or whatever is normally typical. Does this surprise the panel that SJP cases are being brought and deemed proved without any evidence to support the allegations set out in the charge?
Yeah, I mean, I don't think I've done a railway fare one recently enough to remember. I've been doing TfL recently, and the notice quotes what the revenue officer said, so that is evidence. I don't think we'd ever presume guilt. I mean, the presumption is that people are innocent until proved guilty, and you need to be satisfied with what they say. And as I say, railway ones may be different. I don't know. Andrew might be able to help here. I can't remember a railway one, and I haven't done one recently.
If my recollection serves, and it's been 7 months or so now, I think it was section 16F of the Magistrates Courts Act that was introduced as part of the single justice procedure, which relaxed the rules of evidence for single justice cases to some extent. Which meant that you didn't need the same level of evidence. If a case was referred back to open court, then clearly the normal rules of evidence applied. but they were relaxed for single justice work. The magistrate still needs to be satisfied of guilt. It's not a presumption of guilt, but you don't need the same level of evidence. So a statement of the case, of the facts, may suffice in some cases. Clearly, if the magistrate isn't satisfied, they are entitled to dismiss the case. But yes, the rules of evidence are slightly different. I don't think that is the same thing as a presumption of guilt, though. And of course, with the railway cases, if you're talking about designated zones where people must hold tickets, the defences are actually very, very limited. It's almost a matter of strict liability.
Can I mention on strict liability
Yes,
that there is a problem here as well? So we talked about the railway cases where the railway companies prosecuted under the wrong legislation, and Andrew is right in saying those people, were accused of an offence and may well have done it, but it was the wrong legislation. But we've also had, and Tristan wrote a piece about this recently, an issue about the strict liability issue, in that TfL certainly was telling defendants in letters that the offence of not having the right bus ticket was a strict liability offence, which means that you have no, if the offence happened, you have no redress in terms of a reason to dispute the prosecution. But actually, it isn't a strict liability offence. And TfL have not written back to every single defendant who they told it was a strict liability offence and offered to pay back their fines, which they really should. Because if somebody had a defence for why they didn't have the right bus ticket, like the bus conductor said to them, "Oh, don't worry, I know you," then, and they were told that that was totally irrelevant, then actually the conviction should be overturned.
Okay, thanks, Penny. I mean, I think that's really helpful, and I mean, I think it's an example to me of the advantages of the scrutiny that's come out of the single justice procedure by the fact that we're actually seeing more data being available to journalists than it was in the past. I mean, one of the things I've always been keen on is that people are held to account for their prosecution policies. And that there's a level of understanding of what's going on here. I think one of the challenges of technology, increasing the ability of offences to be identified, is that it really does place some of the prosecution policies under scrutiny, because the extent to which speed cameras can catch people these days means that the enormous amount of people are being prosecuted, and some of the sort of hidden discretions in prosecution discretions in the system are being exposed a bit, which I think is only a good thing, really, when it comes down to it.
Kevin, can I just mention one point?
Yes.
In terms of the railway prosecutions that the Chief Magistrate looked at, it wasn't a case of the cases being prosecuted under the wrong legislation. It was that the relevant statutory instrument didn't allow prosecutions under the regulation of the Railways Act to be brought by single justice. They should have been prosecuted under the bylaws, and so the legislation was fine. It was the fact that because they were seeking to prosecute under that legislation, single justice didn't apply. They should have issued a summons.
Okay, thanks. I see Julian has offered an observation in the Q&A, and can I just encourage people? We've got a minute or two left, so if you've got one last question, please do jump in. Which is an interesting one. It's one of the ones that I've struggled with on the grounds of participation. So and Julian's mentioned that prosecutors in many instances have offered out of court disposals to avoid court proceedings, but there's been no engagement, and so which does leave you with the question about do we really need prosecutions at some stage, even if there's no engagement, because compliance otherwise becomes voluntary, and you get to the system where only the people that are actually engaging are the people that are being punished for breaking the law. I mean, this is a tricky thing, isn't it, Penny, about understanding non-compliance, and I think all of these a lot of the discussions is arguments for how we should understand better what is going on in the system, and think about how we deal with that. I don't know whether any of the panel have got any thoughts on that or anything else before we come to a close.
I would say Chris Barth made the point somewhere in the questions about whether there is an ability to know whether those who haven't responded have a mental health issue or some other, very valid reason why they haven't responded. And the answer is we don't know, and that is where I would come back to. I mean, I'd love some research to be done with people accused of SJP offences about how they responded when they got the form, why they didn't respond, or even if they did respond, how they found the process. It's never been done.
That's right. And for my part, I'd probably broaden it out into participation in the justice system. I mean, arguably, you could even broaden it out into participation in society as a whole, when it comes down to it. But it is a particularly challenging issue, and more challenging because offences are more detectable now with modern technology. So it does make it interesting. Okay, we've now run to the end of our time, and any questions that we haven't managed to answer now will be taken away, and we'll have a chance to sort of post some answers to that if we can. And it really just falls to me to thank everybody, our experts, Penny, Jane, and Andrew, as well as everybody who's joined in the discussion, contributed to the Q&A, and just listened. I also have a little plug. It's appeared in the Q&A anyway, but in May, the Centre published the first stage of its work on the use of court fines and how these particularly impact people on low incomes. I mean, that research explored the impact that criminal court fines have on people on low incomes, finding it disproportionately affected them, pushing them further into poverty, destitution, and worse mental health. So that work, which was funded by the Financial Fairness Trust, is now entering its second phase to develop policy solutions to those issues. And it will include considering whether there are some offences that people get fined for that ought to be decriminalised, how to improve the collection of data on people's means and bring it into line with good practice in the debt advice world, and what alternative courts ought to have to the court fine. So that last issue is part of the sentencing review announced yesterday. So if you're interested in those issues, do please get in touch with the team at the centre, and I'm sure these discussions will continue. Maybe we'll have another one on fines a bit later on. So thank you to our panel, and thank you to everybody for joining, and have a good afternoon.